Good morning, everyone. My name is Abhay Singh, and I welcome you on another video analysis session of The Hindu. Today is 2nd of August 2024, and we will start with the first news headline for the day. And the first news headline for the day is that a seven judges bench of Supreme Court has decided that states can sub-classify scheduled castes for the quotas. Now, Supreme Court held that subcategorization within a class is a constitutional requirement to secure substantive equality if the social position of the constituents is not comparable. So what Supreme Court had stated that this take one example, there is a community, not a community actually. So there is a caste uh, schedule, there is a caste schedule caste, ठीक है. अब क्या होगा? अब यहाँ पे एक प्रोविजन क्या बनाया गया कि आप शेड्यूल कास्ट कैटेगरी को बेनिफिट मिलना है, बट शेड्यूल कास्ट कैटेगरी के अंदर कुछ ऐसी कास्ट होंगी जिनको एडिक्वेट बेनिफिट नहीं मिल पा रहा है, जिनको इनफ बेनिफिट नहीं मिल पा रहा है कि वो लोग बेसिकली क्या कर सकें, वो लोग इस बेनिफिट का, इस रिजर्वेशन के स्कीम का बेनिफिट उठा पाए. तो इसकी वजह से क्या हो रहा है, इस वजह से बहुत इंपॉर्टेंट चीज जो हो रही है कि वो बहुत सारी जो कम्युनिटीज हैं वो बैकवर्ड ही रह जा रही हैं. तो सुप्रीम कोर्ट ने बोला है कि हम अलाउ करते हैं इस चीज को, किस चीज को, कि आप किसी भी कास्ट के अंदर, किसी भी कम्युनिटी के अंदर, टेकिंग वन एग्जांपल शेड्यूल्ड कास्ट एज अ होल कम्युनिटी, यू कैन सब क्लासिफाई विद इन द शेड्यूल्ड कास्ट बेस्ड ऑन द बैकवर्डनेस. अगर शेड्यूल्ड कास्ट कैटेगरी के अंदर कुछ ऐसी कास्ट हैं जिनका इनफ डेवलपमेंट नहीं हुआ है, जिनका इनफ प्रोग्रेस नहीं हुआ है, तो आप उनको सब कैटेगराइज करके एक्स्ट्रा बेनिफिट्स प्रोवाइड कर सकते हैं. दिस वाज स्टेटेड बाय सुप्रीम कोर्ट. नाउ in a 6-1 majority judgment on Thursday, a seven judges constitution bench of the Supreme Court, headed by Chief Justice of India Mr. D.Y. Chandrachud, held that the states have the right to sub-classify scheduled castes notified in the presidential list to provide them more preferential treatment in public employment and education. So now what Supreme Court had stated, that Supreme Court had stated that states can states can sub-classify within the group for preferential treatment. So basically what Supreme Court had stated, that a state has the power to sub-classify caste to provide them more benefits in the employment and education. Now it was decided by a seven judges bench which was led by D.Y. Chandrachud. The majority judgment was delivered by Chief Justice of India Mr. D.Y. Chandrachud, whereas the minority opinion or or a single dissenting opinion which was delivered by Justice Bela Trivedi. Now the reasoning given by Justice Bela Trivedi is that states did not have the power to tinker with the presidential list of scheduled castes. So this was the reasoning that was given by Justice Bela Trivedi. She had stated that the states do not have this power where they can twist or change the list which is notified by the President of India under Article 341. So this was the reason that was given by Justice Bela Trivedi कि states उस list से छेड़छाड़ नहीं कर सकते हैं जो under Article 341 notify की जाती है, इसलिए states are not empowered to subclassify, whereas the majority opinion or the majority judgment has held that there is a need to subclassify the caste within the larger community, so that the communities which are backward, which did not get the enough benefits of this reservation scheme, they can get the benefit of the reservation scheme. And in this particular judgment, Supreme Court has also suggested for the introduction of introduction of the creamy layer in scheduled caste and scheduled tribes as well. As of now in India, the concept of creamy layer is only applicable on other backward castes. It's not applicable on any other group. Now four of the seven judges on the bench separately said that, now this is an important observation, four of the seven judges on the bench separately said that government should extend the creamy layer principle to scheduled castes and scheduled tribes as in the case of the other backward classes categories. So now this was the statement which was given by the Supreme Court, that the government should introduce, or government should extend the concept of creamy layer to the scheduled castes and scheduled tribes as well. As of now, this particular concept of creamy layer is only applicable on other backward classes. The principle of, now the another important reasoning that we have to see, and after this particular reasoning we will move to the next important news headline. The principle of subclassification will be applicable to scheduled caste if, now this is the important point because this was stated by the Supreme Court कि हम ये classification कब कर सकते हैं, if the social position of the constituents among the caste or group. Now what is this constituent? So basically this constituent is the that subcaste जिसको benefit मिलने हैं, जिसको additional benefit हमें extend करना है. So the Supreme Court has used the word constituents for these subcategories. Now, if the social position of the constituent among the caste or group is not comparable or subcategorization with the class is constitutional requirement to secure substantive equality. Now, why this subcategorization is done? Why this subclassification is done? To achieve the substantive equality, that there should be equality amongst the larger group as well. Few communities had got the benefit of the scheduled caste subclassification. No, few categories has got the benefit, and they have progressed significantly. So what Supreme Court is trying to say, that this is the right time by introducing the concept of subclassification. States are empowered to uplift those communities as well which are not got the benefit of this reservation scheme, and this particular benefits will be extended. These benefits will be extended in employment and educational sector. The judgment was given by a 7 judges bench, which was authored by Mr. D.Y. Chandrachud, and the minority opinion, or the minority and the minority judgment was delivered by Justice Bela Trivedi. Now, coming on to the second important news headline for the day, and second important news is coming all the way from Paris. At the 33rd Olympics, Mr. Swapnil Kusale has won a bronze medal in 50-meter rifle 3 positions event. Mr. Swapnil Kusale became the third Indian to win a medal at 33rd Paris Olympics after Manu Bhakar and Sarabjot Singh. All these medals have came in. All these medals have came in shooting as well. Third medal is won by Swapnil Kusale in the event 50-meter rifle 3 position. Now moving on to the next important news headline for the day. So basically, Indian Army has stated that no one is alive in the Wayanad disaster zone. So there is a landslide. There is a landslide in Wayanad in which as of now, more than 295 people have lost their life, and this toll is supposed to increase with the rescue operation going on. With the rescue operation going on, this number is supposed to increase. Yesterday, this number was at 122. Today, this number is at 295, and this number is expected to increase more. The team engaged in the rescue and search operations at a landslide hit Churamala in Wayanad have recovered 189 bodies. So till date, 189 bodies have been recovered. 85 men, 76 men, 27 children. So apart from this 189 bodies, 100 different body parts have been also found. This tragedy was huge. These numbers are actually telling the intensity of this natural disaster. And the army has clearly stated that there are very less chances that we found somebody alive in the Wayanad disaster zone. So this news is very sad. This is a kind of a national disaster. This was a kind of a national disaster, and within a few minutes after the landslide, this whole tragic event took place. This whole tragic event unfolded, and 295 people have lost their life. Various states are supporting Kerala at this particular moment of time. Mr. Rahul Gandhi has also visited Wayanad, because Wayanad is his parliamentary constituency. So Mr. Rahul Gandhi has also visited this particular place. Various teams of NDRF, SDRF, Military Engineering Group, Territorial Army, Fire and Rescue Services from Tamil Nadu and Kerala local authorities. So many institutions are providing their help to overcome with this specific natural disaster that took place at Wayanad in Churamala. Okay. Now moving on. So there has been a prediction by the Indian Meteorological Department, and this prediction is basically that there will be above normal rainfall in the month of August and September. Now moving on to the next important news headline for the day. So this statement was given by the law minister of Rajasthan, that Rajasthan may introduce a uniform civil code bill sooner in the Rajasthan Legislative Assembly. Uttarakhand is the first state in India. Uttarakhand is the first state in India which has passed a bill related to uniform civil code, and the bill is known as Uttarakhand Uniform Civil Code Bill 2024. Now this bill was passed in the month of February, and after this Uttarakhand, Rajasthan may become the second state which may pass a similar law related to uniform civil code. Now Uttarakhand is the first state in India to pass a legislation on the passed a legislation on the Uniform Civil Code post independence. Uniform Civil Code is mentioned under Article 44 of the Indian Constitution. UCC is defined, UCC is given under Article 44 of the Indian Constitution, and the most important thing, that post independence Uttarakhand is the only state in India to pass a bill related to Uniform Civil Code, and there is only one state in India. There is only one state in India. Before the passing of bill by Uttarakhand, that Goa is the only state in India which have a thing, which has a similar document like Uniform Civil Code, and the name of that particular document is the Portuguese Civil Code 1867. So Goa has a similar document like Uniform Civil Code, and the name of this document is the Portuguese Civil Code 1867. So these are the few important news headlines from page number 4. And basically Uttarakhand may become the second state in India to pass a bill related to Uniform Civil Code. There are two states in India which are already working on the similar thing, and those two states are Gujarat and Assam. Gujarat and Assam are also working on the same thing. Now moving on to the next important news headline. So again, this spotlight section of 2nd of August 2024 is dedicated to the UPSC aspirant, and not only to the UPSC aspirant, but to all the aspirants who are preparing for different examinations. The kind of situation they are living in, the kind of situation they are facing in the state like Delhi. So there are basically various hubs of these coaching institutes in Delhi, like Mukherjee Nagar and Old Rajendra Nagar, Lakshmi Nagar. So basically, what government is trying to portray this as, it is an accident. But if this particular thing which took place in Old Rajendra Nagar, the civic apathy which took place in Old Rajendra Nagar, where three UPSC aspirants have lost their life. This is not a accident, but this is a man-made disaster. This is a man-made disaster in which three students have lost their life. So basically, this spotlight section is dedicated to these aspirants, and what are the various things that they have to face while preparing for the examination. What are the various conditions they have to face while preparing for this examination? Small rooms, high electricity charges, high food charges, high mess charges, and everything is so messed up when we talk about these UPSC aspirants, the kind of things they have to face. But again, this is how system works. I guess this is how system works, and everybody is a part of system, and nobody is trying to change the system. Everybody is just a part of system. So this is a kind of a sad news. There are there are two tragic events which took place in India. That one was that three students losing their life in a basement. They drowned in a basement, and the second one is at Wayanad, where 295 people have lost their life in a tragic landslide. Now, this particular article of this editorial is very important, and this particular article is, authored by Surit Partha Sarthi. Surit Partha Sarthi is an advocate at Madras High Court, and this particular article is related to money bill and finance bill. So this particular article today, this particular article only talks about money bill. Now we will cover this article in total. We will not leave anything because this is an important topic for every examination. So let's start with the first paragraph. In the coming weeks, a 7-judge bench of the Supreme Court of India is slated to hear arguments over critical questions governing the contours of money bill. So a 7-judge bench of the Supreme Court will decide the questions related to money bill. When Parliament had decided or chosen a second door to pass many bills as money bills, because they have the majority in the Lok Sabha, they don't have the majority in the Rajya Sabha. So what they took an indirect route and got passed many bills as money bills. Now let's look deep into this particular article. The reference to the 7-judge bench emanates out of a verdict rendered in November 2019 in Roger Matthews versus South Indian Bank Limited, in which the Finance Act 2017 was under challenge. The act, which was passed after its certification as a money bill, radically altered the authority and jurisdiction of 26 different tribunals. It abolished some of these bodies, merged together others, prescribed qualification for appointment of members, and imposed various other stipulations, including conditions of services. So basically, when the Finance Act of 2017 was challenged in Roger Matthew versus South Indian Bank Limited, and after the introduction of this Finance Act as a money bill, the various provisions have been changed. The heads of 26 tribunals were affected. Basically, the working of 26 tribunals were affected. Few tribunals were abolished, few were merged, and the qualifications for the appointment was also twisted. So this is all about Finance Act 2017, and basically in Roger Matthews versus South Indian Bank Limited. This particular case, this particular Finance Act of 2017 was challenged. Now we have to understand one thing before going into this particular article a bit more, that there is a difference between money bill and finance bill. Article 110 clause 1 subclause A to G of the Indian Constitution defines the term money bill, whereas Article 117 of the Indian Constitution defines the term money bill. Now, the best thing about the money bill is that the Speaker of the Lok Sabha is the final authority to decide whether a bill is a money bill or not. Now, the second important thing is, and it is only this particular privilege is only available to the money bill, and that particular privilege is that if a bill is introduced as a money bill in Lok Sabha, then Rajya Sabha becomes toothless. Then Rajya Sabha becomes toothless. They do not have any kind of power related to money bill. They do not. They cannot give binding recommendations. The bill is not necessarily to be passed by Rajya Sabha if a bill is money bill. So basically, this is the route that was adopted by the Bharatiya Janata Party, and this has been challenged in the Supreme Court. Now, in Roger Matthew, the petitioner argued that these changes were too far extensive to meet the criteria required of a money bill. Under India's constitutional structure, for a bill to turn into law, it must obtain the sanctions of both the houses of the parliament. Now, so in India, it is a settled principle to become an act or for a specific bill to become a law. It is required that particular bill should be passed by both the houses of the parliament, that is the lower house, that is Lok Sabha, and the upper house, that is the Rajya Sabha. But there is one exception to this settled proposition of law, and that particular exception is related to money bill. मनी बिल को ऐसी कोई रिक्वायरमेंट नहीं है कि मनी बिल के साथ में ऐसी कोई रिक्वायरमेंट नहीं होती कि उसका दोनों हाउसेस से पास होना जरूरी है. मनी बिल सिर्फ और सिर्फ लोकसभा से पास होना जरूरी है, और स्पीकर ऑफ द लोकसभा is the final authority which can decide whether a bill is a money bill or not. The only exception, which is contained in Article 109, allows money bill to be enacted as law within only the Lok Sabha's approval. The Rajya Sabha may make recommendations on the bill, but any suggestions from it would not be bind the Lok Sabha in any way. So, basically, Rajya Sabha can give suggestions, Rajya Sabha can give recommendations in the money bill, but these recommendations are not binding. And under Article 109 clause 5 of the Indian Constitution, it has become abundantly clear that Rajya Sabha can hold a discussion on money bill only for a period of 14 days, and if they do not pass the bill within the 14 days, then it will be assumed that the bill has been passed by them, or they have passed that particular specific bill. So they will get the bill only for 14 days. They can discuss that particular bill, but they cannot pass that particular bill. They cannot suggest some binding recommendations. So how powerful is money bill? You can understand this by utilizing Article 109, and by utilizing Article 109, this parliament has utilized this particular power of money bill, and they have introduced so many bills as money bill. That's why we are discussing this particular article, and Article 110 clause 1 of the Indian Constitution clearly defines the term money bill. Article 110 clause 3 further makes it clear that the Speaker of the Lok Sabha shall have the final say in determining whether a proposed legislation is a money bill or not. Now, Article 110 clause 1 subclause A to G defines the term money bill, and Article 110 clause 3 makes it very clear, makes it abundantly clear that the Speaker of the Lok Sabha is the final authority to decide whether a bill is a money bill or not. Now, who is this Speaker? Who is this Speaker? So in India, this is the 18th Lok Sabha, and in India there have been only two exceptions when the Speaker of the Lok Sabha is a person or a member from the opposition, and at all other occasions the Speaker of the Lok Sabha is always from the ruling party. If ruling party is trying to introduce some bill as a money bill, and the Lok Sabha Speaker is the final authority to certify whether a bill is a money bill or not. Now, Speaker of the Lok Sabha is also a member of ruling party. So these all things are correlated. Not only this particular question should be raised in the House, but the authority of the Speaker should also be challenged. Why? Because it is, at the end of the day, it is the speaker of the Lok Sabha who has the final authority to decide whether a bill is a money bill or not. Now, on a simple reading of the definition, it ought to be obvious that the use of the word only means that a bill has subjects in which it are more than merely attendant to those delineated in Article 110, Clause 1 can never qualify as a money bill. Yet, this is precisely what the Finance Act 2017 sought to do. Now, usually a finance act is passed at the beginning of every year to outline the state's physical plan. Now, this is a convention that, finance act is passed at the beginning of every year, to chalk out the plans related to the state revenue and state expenditure. The law, quite apart from rearranging panels and bodies, also granted to the union executive a carte balance to make rules and how subsisting tribunal was to be administered. So now this Finance Act of 2017, which is challenged, which has been challenged. Now, the main important provisions which was related to related to Finance Act 2017, that by making amendments, by virtue of Finance Act 2017, the Parliament has restructured so many tribunals in India. क्या क्या चीजें हुई, क्या क्या चीजें हुई, कुछ जो एग्जिस्टिंग ट्रिब्यूनल्स थे उनकी पावर बढ़ा दी गई, उन ट्रिब्यूनल्स में जो मेंबर आएंगे उनकी क्वालिफिकेशंस को डाउनग्रेड किया गया, उन मेंबर्स को जो लोग सेलेक्ट करके लाएंगे, जो सेलेक्ट कमेटी हो गया, जो सिलेक्शन कमेटी हो गया, जो सिलेक्शन पैनल होगा, उसकी भी क्वालिफिकेशंस को कम कर दिया गया. Now all these things are related, all these things have been done by the virtue of Finance Act 2017. Now we have to understand that the money bill is specifically related to the Consolidated Fund of India. If there has to be any appropriation made in the Consolidated Fund of India, then that will be dealt under the money bill. So basically what logic has been given by the Parliament, that these members, the salary aspect of these members have been touched, the salary aspect of these members have been touched. So that's why these particular bills are money bill, क्योंकि इनकी जो सैलरी आएगी इन एम्प्लॉयज की या इन अथॉरिटीज को जो सैलरी मिलेगी, वो सैलरी कहाँ से मिलेगी? That will be appropriated from Consolidated Fund of India. That's why these bills are introduced as money bill. Now this is the logic that is being given by the Parliament. Now, there is no doubt that the Finance Act had elements in that it touched on subjects contained in Article 110 Clause 1. For example, the law determined the salaries payable to the members of tribunals out of the Consolidated Fund of India. So under Article 110 Clause 1, it is given that if any appropriation have to be made out of the Consolidated Fund of India, then that particular bill will be treated as money bill. So यहाँ पे क्या रीजनिंग यूज किया गया है कि ट्रिब्यूनल्स और के जो मेंबर्स होंगे, जो ऑफिसर्स होंगे, उनको सैलरी तो कंसोलिडेटेड फंड ऑफ इंडिया से ही दिया जाएगा, इसीलिए ये सारे के सारे बिल क्या थे? मनी बिल थे. In many ways, the court's job in Roger Matthew ought to have been simple enough. After all, under no circumstances could changes through a money bill to terms of office or the conferral on the executive or unbridled power to regulate tribunals through delegated legislation or the incorporation of provisions on qualifications for the appointment through a money bill be seen as anything but an act of subterfuge. It was therefore plainly evident that the Finance Act 2017 was a colorable exercise of power. Now, what is this colorable exercise of power? So, what cannot be done directly cannot be done indirectly. So, basically, अब सुप्रीम कोर्ट का काम बहुत आसान होने वाला है. इस रोजर मैथ्यू वर्सेस साउथ इंडियन बैंक लिमिटेड केस में द जॉब ऑफ सुप्रीम कोर्ट इज गोइंग टू बी एब्सोल्युटली इजी. Now I am saying this, the job of Supreme Court is going to be absolutely easy. The only reason is that look at the things. आप किसी की पावर को कम कर रहे हैं, आप क्वालिफिकेशंस जो रहेंगे मेंबर जिनको अपॉइंट करना है उनकी क्वालिफिकेशंस को कम कर रहे हैं, आप ये सारी चीजें कर रहे हैं. पार्लियामेंट इज डूइंग ऑल दीज थिंग्स. हाउ दीज थिंग्स आर रिलेटेड टू कंसोलिडेटेड फंड ऑफ इंडिया? नो, appropriating or taking out the salaries from the Consolidated Fund of India, that is something related to the money bill. But there comes another question. Was there any need to introduce a common bill for everything? There has to be separate introduction of different bills, that if you want to increase or decrease the salary of the members, then you have to introduce it as a money bill. And if you don't want to increase or decrease the salary, but instead of that you want to increase or decrease the qualification of the members, then you have to introduce it as a finance bill, because nowhere it is related to the Consolidated Fund of India. Now, so this is a kind of colorable exercise of the power. Now, what is this colorable exercise? The meaning of colorable exercise is very simple. The thing which cannot be done directly also cannot be done indirectly. जो चीज आप directly नहीं कर सकते उस चीज को आप indirectly भी नहीं कर सकते. This is the colorable legislation. The majority of the five judges bench saw itself constrained by a prior precedent. It found that a coordinate bench in case Puttaswamy versus Union of India. Now this is the case Puttaswamy versus Union of India, in which Supreme Court has declared that privacy is a fundamental right of a person. And in the same case, which is also known as Aadhaar case, where the validity of Aadhaar regime was challenged, has failed to provide a sufficiently clear bright line rule on the standards to be employed in reviewing a speaker's decision to certify a draft laws as a money bill. So basically, in this particular case Puttaswamy versus Union of India, it was challenged that the Aadhaar bill was also introduced as a money bill. So in this particular case, Supreme Court has upheld the validity of Aadhaar Act and also stated that Aadhaar card was a money bill. So basically, what the author is trying to say that in this particular case, only case Puttaswamy versus Union of India, uh, Supreme Court could have done what Supreme Court could have done, that they have clarified. So they should have clarified on the same, that what test we should adopt to check whether a bill is a money bill or not. So if the thing would have been decided in case Puttaswamy, then the future things would have been easier for the Supreme Court as well, because this was the first opportunity where the Supreme Court has could have done all these things, that they should have devised, or they should have developed a test, that this is a money bill test. If you will fulfill all these conditions, or if your bill has all these conditions, then only you can introduce this bill as a money bill. Now also someone can say this is this is in violation of the constitution. The judiciary is not required to interfere in the working of the parliament. But again, we have to understand what parliament was required to do, that it is not required to adopt an indirect route to pass many bills in India. Justice A.K. Sikri, who wrote the majority opinion there, concluded that because Section 7 of the Aadhaar Act concerned subsidies, benefits, and services for which expenditure was to be incurred from the Consolidated Fund of India, the law met the condition of a money bill. Now, in that particular case, in the case Puttaswamy versus Union of India, it was challenged whether because Aadhaar bill was also introduced as money bill. So the primary question which was challenged in the Supreme Court, that Aadhaar bill is not a money bill; it is a finance bill. But what Justice A.K. Sikri in his majority opinion written, that Section 7 of the Aadhaar Act is related to the subsidies and benefits which has to be provided to the beneficiaries, and these benefits will be provided from the Consolidated Fund of India. So this is specifically, this particular thing met the criteria of a money bill. So that's why this Aadhaar bill is a money bill. So now this was given in this case Puttaswamy versus Union of India. Now, properly construed, these matters could scarcely be seen as incidental to the subjects in Article 110 Clause 1. It now falls within the remit of the world only. Any decision from it will have enormous consequences. This is because both before and since the reference in Roger Matthew, there have been instances where the Rajya Sabha have been bypassed. So now, why this indirect route of money bill is used by the parliament to bypass the powers of the Rajya Sabha? Because if any other bill is introduced except a money bill, then there is this prerequisite that particular bill needs a nod from both Lok Sabha and Rajya Sabha, but a money bill only needs a nod from Lok Sabha only. Notably, the Finance Act 2019 made far-reaching amendments to the PMLA Act through a money bill. The changes made included alteration to the definition of what constitutes as a proceeds of crime. So basically, these are various examples, which are trying to illustrate, which author is trying to illustrate, which our author has given his best effort to make certain things clear. That this Finance Act of 2019, through Finance Act of 2019, this huge change has been done in Money Laundering Act, PMLA, Prevention of Money Laundering Act 2002. And what changes have been done? A specific term, proceeds of crime, has also been changed. Now we have to understand one more thing. If a bill is introduced in the Lok Sabha, for example, if a bill is introduced in the Lok Sabha, for take an example, Finance Act 2024. Now, when this bill was introduced, this is a complete bill. Now, only one aspect of this bill is related to the Article 110 Clause 1 of the Indian Constitution. Rest of the article does not satisfy or not meet the conditions which are given under Article 110 Clause 1 of the Indian Constitution. Then what course of action should be adopted by the Speaker of the Lok Sabha? Because at the end of the day, it is the Speaker of the Lok Sabha who has the final say in matters related to whether a bill is a money bill or not. So these are the things that we have to keep in our mind. Any decision from it. Now, the Supreme Court upheld many of those amendments in Vijay Mandal Chaudhary versus Union of India, but kept open the question of whether the amendments could have been validly made through a money bill or not. Now, in each and every case, when the question was related whether a bill is a money bill or not, there are two kind of questions that we have to understand. Take one example of Aadhaar card. Case Puttaswamy versus Union of India. So, in what happened in case Puttaswamy versus Union of India, two things happened. First, the validity of Aadhaar Act was challenged. So Supreme Court has upheld the validity of Aadhaar Act and it has stated that it is purely constitutional. Now the second question which was in front of Supreme Court, whether the Aadhaar bill was introduced as a money bill which can be challenged or which was correct or not. So Supreme Court had stated that by using the sections of Section 7 of Aadhaar Act, it is clear that it is related to the Article 110 Clause 1. So it is a money bill. Now the two things that are being challenged continuously are, the first one is जिस एक्ट में चेंजेस किए गए उसकी वैलिडिटी को चैलेंज किया जाता है, और सेकंड क्वेश्चन जो आता है कि उस बिल को जो मनी बिल की तरह इंट्रोड्यूस किया गया है उसको चैलेंज किया जाता है. तो सुप्रीम कोर्ट इन मोस्ट ऑफ द जजमेंट हैज upheld the validity of law itself, but it had questioned the indirect route that have been adopted by the parliament while introducing that particular bill as a money bill. Now we have to understand there is this whole thing that is going on, that in first there was a Aadhaar card judgment case Puttaswamy versus Union of India 2018 judgment. In this particular judgment, in this particular judgment, the validity of Aadhaar bill was changed, which was later upheld by the Supreme Court, and it has also stated that the introduction of Aadhaar bill as a money bill is absolutely correct. Now there was another case in 2019, Roger Matthew versus South Indian Bank Limited. In this particular case also, this question of money bill and finance bill raised. So there was a there was a clear stand by the Supreme Court, and this particular judgment, in this Roger Matthew versus South Indian Bank Limited, the judgment is yet to come. The judgment is yet to come, but again we have to understand the whole point of this discussion is only related to money bill. और ये हम अभी क्यों डिस्कस कर रहे हैं, क्योंकि पार्लियामेंट ने एक इनडायरेक्ट रूट को अडॉप्ट किया है इन सारे बिल्स को मनी बिल की तरह इंट्रोड्यूस करने के लिए. ठीक है, अब हम लोग आ जाते हैं नेक्स्ट इंपॉर्टेंट एस्पेक्ट पे, एंड दिस इज रिलेटेड टू बेसिकली ब्रॉडकास्टिंग सर्विसेज रेगुलेशन बिल 2023. बहुत ज़्यादा डिटेल में नहीं जाएंगे क्योंकि इसका एक प्राइमरी रीज़न ये है कि इस बिल की जो कॉपी है वो सबको नहीं प्रोवाइड की गई है. इस बिल की कॉपी बहुत लिमिटेड स्टेक होल्डर्स को प्रोवाइड की गई है और एब्सोल्युटली सिर्फ उन्हीं के पास इसका कॉपी अवेलेबल है, एंड दैट टू विद अ वाटर मार्क. और वो ऐसा वाटर मार्क है कि अगर आप उसे कहीं पे लीक करने की कोशिश करेंगे देन द अथॉरिटीज विल अंडरस्टैंड. सो बेसिकली ये जो ब्रॉडकास्टिंग रेगुलेशन सर्विसेज रेगुलेशन बिल 2023 आ रहा है, ये बहुत कॉन्ट्रोवर्शियल काइंड ऑफ बिल हो सकता है. इसीलिए क्या किया गया है कि सिर्फ कुछ गिने चुने स्टेक होल्डर्स को इसकी एक कॉपी प्रोवाइड की गई है. अब देखिए, जो इसके पहले बिल इंट्रोड्यूस किया गया था उसमें क्या किया था कि गवर्नमेंट ने सब पब्लिक डोमेन में बिल को रिलीज किया था, बट एज ऑफ नाउ इट हैजंट बीन डन. अभी ये ब्रॉडकास्टर सर्विसेज रेगुलेशन बिल 2023 इसलिए भी इंपॉर्टेंट है क्योंकि अब बहुत सारी नई चीज़ें होने वाली हैं. ऑनलाइन कंटेंट क्रिएटर जो होते हैं, जो सोशल मीडिया पे कंटेंट क्रिएट करते हैं, उन्हें भी इसमें इंक्लूड किया जाएगा. Now coming on to the next important article from the editorial, that this is related to genetically modified crops. जेनेटिकली मॉडिफाइड क्रॉप्स, इस पे एक ये आर्टिकल है और ये आर्टिकल बहुत इंपॉर्टेंट है क्योंकि रिसेंटली 2 जजेस बेंच ने एक जजमेंट डिलीवर किया एंड इट इज़ अ स्प्लिट वर्डिक्ट. 2 जजेस बेंच ने स्प्लिट वर्डिक्ट डिलीवर किया है और इसका बेंच का बेंच में था कौन कौन? जस्टिस बी वी नागरत्ना एंड जस्टिस संजय करोल. नाउ India's torturous saga on the fate of genetically modified food crop made another pit stop last week. There were 2 judges bench of justices B.V. Nagaratna and Sanjay Karol of the Supreme Court of India delivering a split verdict on the questioning of allowing genetically modified mustards in farmer fields. So basically, there is no benefit of this judgment. Why? Because this is a split judgment. What is this split judgment? जहाँ पे 2 judges की bench अलग अलग ओपिनियन रखती है. एक लोगों का मानना है कि चीज़ होनी चाहिए और एक लोगों का मानना है कि चीज़ नहीं होनी चाहिए. सो दिस इज अ स्टेटस को, इसमें फिर कुछ चेंज नहीं आता. ठीक है, अब जस्टिस बी वी नागरत्ना और जस्टिस संजय करोल की जो ये बेंच थी, इन्होंने लास्ट वीक डिसाइड किया कि जेनेटिकली मॉडिफाइड जो ये मस्टर्ड क्रॉप है इसे हमें अलाउ करना है नहीं. एज ऑफ नाउ इंडिया में सिर्फ एक ही जेनेटिकली मॉडिफाइड क्रॉप है जो एग्जिस्ट करता है और वो कौन सा है? कॉटन सीड्स. सिर्फ इंडिया में अभी कॉटन सीड्स ही इकलौते ऐसे हैं जिसमें जेनेटिकली मॉडिफाइड क्रॉप का यूज़ किया जाता है ना. अब इंडिया में अभी तक मस्टर्ड ऑयल को लेकर के या जो मस्टर्ड सीड्स थे उसी में बेसिकली था ये जेनेटिकली मॉडिफाइड सीड्स का हम लोग यूज़ कर रहे थे. अब इसका नाम क्या था, DMH11, धारा मस्टर्ड हाइब्रिड 11, दैट वाज डेवलप्ड अंडर अ पब्लिकली फंडेड प्रोजेक्ट एट दिल्ली यूनिवर्सिटीज बायोटेक्नोलॉजी डिपार्टमेंट. The genes used in this plant make the crop suitable and lucrative to private seed companies for making newly hybrid varieties. For crops to be approved under India's agriculture system, they must be sown over 3 seasons in different agroclimatic zones and prove themselves to be consistently better than their existing comparators. So basically, this was the first essential requirement which need to be fulfilled. That basically this genetically modified crop has to prove that they are better than their existing comparators. So basically, this was the first criteria. उन्हें अलग अलग 3 अलग अलग सीजन्स में अलग अलग एग्रोक्लाइमेटिक कंडीशंस में हम ग्रो करके देखेंगे कि कहाँ पे वो क्रॉप कैसा परफॉर्म कर रही है. नाउ DMH11 इज जेनेटिकली कोडेड इन अ वे. अब DMH11 धारा मस्टर्ड हाइब्रिड 11 जो सीड था, इसे मस्टर्ड सीड. अब इसके बारे में हम थोड़ा बात कर लेते हैं. It is a genetically coded in a way that effectively forces farmer to use certain kinds of pesticides with destructive environmental consequences. The allegations are that developers were not transparent with the information. These findings and GIAC approval have been contested in the court by Aruna Rodriguez and the organization of the Gene Campaign. So basically, the petition was filed by the Gene Campaign, and Aruna Rodriguez was representing them. So basically, what argument has been made by the defendants, or no, what argument was being made by the petitioners, that this particular crop DMH11, ये इस तरीके का जेनेटिकली मॉडिफाइड क्रॉप है कि इस पर्टिकुलर क्रॉप को सर्वाइव करने के लिए हमें बहुत सारे तरीके के पेस्टिसाइड्स का यूज करना होगा, विच विल इनडायरेक्टली अफेक्ट द इन्वायरमेंट. So basically, this was the main reason that was given by the petitioner, that अगर जेनेटिकली मॉडिफाइड या जेनेटिकली कोडेड क्रॉप है भी, और उससे हमारा मेन ऑब्जेक्टिव जो था प्रोडक्शन इन्हांस करना, वो प्रोडक्शन इन्हांस कर भी हो भी गया, बट अगर जो उसके इन्वायरमेंटल कॉन्सिक्वेंसेज होंगे, क्योंकि उस पर्टिकुलर क्रॉप को सर्वाइव करने के लिए DMH11 को यू नीड टू हैव अ लॉट, यू नीड टू यूज अ लॉट ऑफ पेस्टिसाइड्स. सो देयर विल बी नो बेनिफिट, क्योंकि वो इनडायरेक्टली कहीं ना कहीं जाकर के जो चीज़ आप इधर से कवर करने की कोशिश करें, वो कहीं और पे जाकर के खराब हो जाएगी. आप प्रोडक्शन बढ़ाने की बात करें, वो जितना प्रोडक्शन बढ़ेगा उससे ज़्यादा वो इन्वायरमेंट को डैमेज कर देगा. ठीक है, तो ये सारे आर्ग्यूमेंट्स यूज किए गए. अब जेनेटिकली मॉडिफाइड क्रॉप का इंडिया में अभी होना क्या है, अभी इनका करंट में स्टेटस क्या है, कैसे चीज़ें सामने निकल के आएंगी, कैसे हम एक प्रॉपर स्टडी कंडक्ट करनी पड़ेगी किसी भी क्रॉप को इंट्रोड्यूस करने से पहले. तो ये सारी चीज़ें इस आर्टिकल में डील की गई हैं. एंड द लास्ट थिंग, सुप्रीम कोर्ट ने एक लार्जर बेंच कॉन्स्टिट्यूट किया है ताकि एक फर्म डिसीजन आ सके, क्योंकि अभी जो जजमेंट है वो स्प्लिट वर्डिक्ट है. स्प्लिट वर्डिक्ट का मतलब क्या होता है, दो लोग दो अलग अलग तरीके के ओपिनियन. ठीक है, सो दिस वाज ऑल रिलेटेड टू द एडिटोरियल पार्ट ऑफ द हिंदू. नाउ वी विल मूव टू द नेक्स्ट इंपॉर्टेंट हेडलाइन. So this Ursula von der Leyen, have been elected as the फीमेल प्रेसिडेंट ऑफ द यूरोपियन यूनियन कमीशन. यूरोपियन यूनियन कमीशन की नई प्रेसिडेंट बन गई हैं उर्सुला वॉन डर लेन. नाउ अब हम लोग नेक्स्ट इंपॉर्टेंट पॉइंट पे बढ़ेंगे. मेंटल हेल्थ मैटर्स, द साइकोलॉजिकल प्रेशर ऑफ यूपीएससी प्रिपरेशन. Now this particular exam is so hyped in India, this particular examination is so hyped in India that even after a success rate of 0.1%, so now there's even with the success rate of 0.1%, there are close to a million applicants for this particular examination every year. Now this the very preparation, now the very authority have been questioned. Now there are two instances in last 1 month that have raised eyebrows over the Union Public Service Commission, and the first one was related to Pooja Khelkar. Pooja Khelkar, that was a direct or a blatant attack on the authority of Union Public Service Commission, that there was an aspirant who has fooled UPSC in so many possible ways, and and that particular woman has got allocated the services as well. She was the IAS. She was serving as Indian. She was serving in Indian Administrative Services. And now the second event is not actually related to this commission as a commission, but it is related to the students who are preparing for Union Public Service Commission Civil Services examination. The kind of conditions they are facing while they are living in Old Rajinder Nagar and Mukherjee Nagar, part of Delhi. The stakeholders are not coming, the stakeholders are not participating, except the students. No one is taking part in this particular agitation or the protest which is being organized by the students. So we have to understand that in India, this giving the god status to exams like these left a lot of pressure on the students as well. So we have to understand and we have to maintain a balance between these two things. because if you don't balance these two things, then students will take the risk, and they will take such steps. Now before going into that library, the students were aware, but again this is a kind of pressure that they face, that they just focus on only one thing, and that is your UPSC exam, civil services examination. And this particular examination, the preparation journey of this particular examination is so tough. It will test you on each and every possible level. It will test your patience, it will test your perseverance, it will test your mental state, it will test your physical state, it will test your financial state. Because the rent in Mukherjee Nagar, the rent in Old Rajendra Nagar for a small room, like it's a 12 by 12 room, it's a 10 by 10 room, and the rent is 15,000 rupees per month. My friend was living in Old Rajendra Nagar, he used to pay a rent of 23,000 per month. Now this is the kind of parity that we have to understand, that if you want to take A class services, then you should have a minimum of 40,000 rupees in your pocket, that you have to spend in every month. After paying a fees of 2.5 lakh, you need to have a minimum of 40,000 rupees in your pocket to survive in Old Rajendra Nagar. And after investing this much of money, students are not getting basic benefits, basic facilities. So this is a thing which is in question. So again, this particular article is related to that aspect only, the mental state of the students, of the UPSC aspirants. Now we will move to the next important article. This is basically related to that subcategorization. Chief Justice Chandrachud traced the power of these states to subclassify the scheduled caste for the purpose of affirmative action, including reservations to Article 15, Clause 4, prohibition of discrimination on grounds of religion, caste, etc., and 16, Clause 5, equal opportunity in public employment of the Constitution. Now, this particular decision which I have discussed earlier, that a seven judges bench of Supreme Court, with a majority of 6 to 1, had stated that states can subclassify scheduled caste for the quotas. Now, the Supreme Court has derived the power, or no, Supreme Court has actually given this particular verdict on the basis of Article 15 Clause 4 and 16 Clause 5 of the Indian Constitution. So these two articles have been used to provide this benefit of subclassification. The Chief Justice agreed that the scheduled caste was not an indivisible monolith. The scheduled caste notified by the President under Article 341 Clause 1. So basically, it is the President who notified the list of the scheduled caste in India under Article 341 Clause 1 of the Constitution, was composed of heterogeneous groups of caste, races, or tribes with varying degrees of backwardness. Their inclusion in the President's list by Parliament under Article 341 Clause 2 did not mean they were a uniform and internally homogeneous unit incapable of further subclassification. Now, what Supreme Court had stated, that the benefits are given on the basis of backwardness. So if this whole community is backward, we will give benefit to the whole community. But if there are certain categories or certain caste within that particular group, within that particular monolith, then we have to provide extra benefits to those candidates as well, to uplift them, and to provide them equal opportunity. So this was stated by the Supreme Court. There are three important provisions that we have to keep in mind: Article 15 Clause 4, 16 Clause 4, 16 Clause 5, 341, 341 2. Now what is this 341 Clause 1? Under Article 341 Clause 1, it is the President of India who notified who notified that particular list which have all the caste of the scheduled caste community. Now, and this particular list is prepared by the Parliament, notified by the President, and till date there was no standard of sub-classification. There were various kind of demands from the different corners of the country. Suppose take one example of Madiga community. So the Madiga community, since 1994, Madiga community is demanding for the sub-classification. They have their own set of statement. They believe that they have not been given enough benefits. So these are the various examples under this particular article. We have to understand that. So it was a seven judges bench. It was a seven judges bench, constitutional bench. Judgment were delivered by 6 to 1 majority. माइनॉरिटी ओपिनियन जस्टिस बेला त्रिवेदी का था. मेजोरिटी ओपिनियन को ऑथर किसने किया? जस्टिस डी वाई चंद्रचूड़ ने किया. किन आर्टिकल्स को डिस्कस किया गया? 15 क्लॉज 4, 16 क्लॉज 5, 16 क्लॉज 4 ऑफ द इंडियन कॉन्स्टिट्यूशन, आर्टिकल 341 ऑफ द इंडियन कॉन्स्टिट्यूशन. ठीक है. अब जो ये 2024 में जजमेंट आया, इसने एक बहुत ही 19 ईयर्स पुराने जजमेंट को ओवरटर्न किया है. इस जजमेंट के बारे में थोड़ा सा देख लेते हैं. द मेजॉरिटी जजमेंट ओवररूल्ड अ 2005 वर्डिक्ट ऑन द AV Chennaiya case, which had held that sub-classification amounted to tinkering with the presidential list by the state legislature and was therefore violative of Article 341 Clause 2, which exclusive vest power in Parliament. So there was this judgment of E.V. Chinaya case. This E.V. Chinaya judgment was delivered in the year 2005, and in this particular judgment, the Supreme Court had stated that this sub-classification is against the constitutional principles because it directly twists the list which is exclusively prepared by the Parliament and notified the President. So this 19-year-old judgment of E.V. Chinaya case has been overturned in 2024. Now Supreme Court has allowed the sub-classification of scheduled caste community. And also Supreme Court has suggested the Parliament that they should also consider this introducing this concept of creamy layer, in the scheduled caste and scheduled tribes as well. So this is the case. This picture is actually the representation of 50% of India's population during rainy season. रेन वाटर लीकिंग फ्रॉम द सीलिंग ऑफ द न्यू पार्लियामेंट बिल्डिंग और नीले रंग की बाल्टी वहां पे रख दी गई है. तो ऐसा सिर्फ पार्लियामेंट में नहीं हो रहा. पार्लियामेंट इज द एक्चुअल पिक्चराइजेशन ऑफ इंडिया. पार्लियामेंट में वही होता है जो पूरे इंडिया में हो रहा है. तो पूरे इंडिया में जब पानी टपक रहा है तो पार्लियामेंट में भी टपक रहा है. सो दिस नथिंग न्यू, नथिंग बिग. So Lieutenant General Sadhana Saxena Nair assumed the office of Director General Medical Services on Thursday, today becoming the first woman to be appointed to this position. So Mrs. Lieutenant General Sadhana Saxena became the first woman to be appointed as the Director General of Medical Services Army. So Mrs. Sadhana, Lieutenant General Sadhana Saxena became the first woman in India to hold the position of Director General in Medical Services Army. Now moving on to the next important news headline for the day. Then we have come, we moved on to this business section. So the GST recipient has saw an increase of GST receipt has saw an increase of 10.3%, and this is the third time. This is the third best month. दिस इज द थर्ड बेस्ट जुलाई. जीएसटी इंट्रोड्यूस करने के बाद जो 2024 का जो जुलाई है ये तीसरा सबसे अच्छा जुलाई बन गया इन टर्म्स ऑफ जीएसटी कलेक्शन. अब क्या हुआ है कि डे बिफोर यस्टरडे इजराइल हैज किल्ड द फाउंडर ऑफ और द regulator of this Hamas, and the regulator of Hamas is Ismail Haniya. Ismaili Haniya have been killed in a airstrike by the Israeli forces, and Iran has said that it will provide the befitting reply to Israel. Iran has said that it will provide befitting reply to Israel. The second question is related to Venezuela, where the presidential elections have been questioned. That the sitting president of Venezuela, Nicolas Maduro, has adopted some unfair means to win this particular election, and these allegations have been denied by Nicolas Maduro. Now moving on to the next important news headline, and this is again coming all the way from Paris. Yesterday it was a disappointing day for India. India has performed poor in so many areas. So many athletes which were the top contender for the medals at 33rd Olympics, they have lost their respective bouts. Now the good news that is coming from the 33rd Olympics at Paris, that Mr. Swapnil Kusale has won the third medal for India. He has won a bronze medal. He has won a bronze medal in 50-meter rifle 3 position. So basically this is one news. This is a good news. So this is India's third bronze medal in 2024 edition of Olympics, won by Swapnil Kusale. And previously medals have been won by Manu Bhakar and Sarabjot Singh. So basically now this is a kind of distressing news that Nikhat Jareen has lost a pre-quarter final bout. She lost a pre-quarter final bout, and she was the top contender for India. She was the top contender, and everybody was so sure that she will take at least one medal from Paris. But she was disqualified. She has lost his pre-quarter final bout. Now the second or the third news that is related to badminton, that PV Sindhu and Satvik Sai, Ranki Reddy and Chirag Shetty has lost their respective matches, and they are out of the 2024 Paris Olympics. So now with this last news is basically related to this boxing event. So this Algerian boxer Imane Khalif. So last year Imran Khalif failed a gender eligibility test. So basically, his testosterone level is high, and because of that, he failed a gender eligibility test, and he was disqualified from the world championship. Now he is participating in Olympics, and his opponent in the first round, his opponent has ended the fight after 46 seconds because of this dominant male traits, क्योंकि बॉक्सिंग जैसा गेम है, और अगर आप पिछले साल ही आपने अपना जेंडर एलिजिबिलिटी टेस्ट फेल किया है, विच मीन्स आपका टेस्टोस्टेरोन लेवल हाई है। टेस्टोस्टेरोन लेवल हाई है मतलब आपके अंदर जो ट्रेट्स होंगे वो थोड़ा सा मेल्स के ट्रेट होंगे, और मेल फिजिकली कंपैरेटिवली स्ट्रॉन्गर देन फीमेल। इट इज़ अ सेटल्ड प्रिंसिपल दैट मेल्स आर कंपैरेटिवली स्ट्रॉन्गर देन फीमेल्स। अब यहाँ पे ये होता है कि ट्रेन करके फीमेल्स भी मेल के बराबर आ सकती हैं। तो बेसिकली यहाँ पे पॉइंट ये है कि वो जो सामने वाला इंसान है इज पार्टिसिपेटिंग एज अ वुमेन, बट ही हैज़ अ ट्रेट एज अ मेल। तो वो कहीं पे आप इक्वालिटी आप कर ही नहीं सकते हैं, और फीमेल नहीं है, इट्स अ प्रोफेशनल गेम, तो इसमें सामने वाला इंसान भी तो प्रैक्टिस कर रहा है ना। सो दीज आर द थिंग्स विच वी हैव टू अंडरस्टैंड। बट अगेन, यहीं पे आज का न्यूज़ एनालिसिस हम ख़त्म करेंगे। अब आज के न्यूज़पेपर में इसके अलावा कुछ भी इंपॉर्टेंट नहीं है। सो फ्रैंकली वी हैव to end it here. We have to end it here. So with this, we have completed the news analysis of 2nd of August 2024. And I hope if you guys have any questions related to money bill or finance bill, and or related to the subcategorization which has been which has been upheld by the Supreme Court overturning a 19-year-old judgment of EV Chinaya case. So these are the two important highlights for from the today's newspaper. And if you guys have any questions related to this newspaper, you can easily punch into the comment sections. So with this, we are completing. We are wrapping up this session. Thank you so much for watching today's video. Please do like, subscribe this Success Mitra Digital channel. Thank you.